Lord, your lordships were examining two competing interests, namely, one, right to know, and second, right to have informational privacy. And your lordships have accepted information privacy to be a fundamental right. If, my lord, I am the person donating, and if your lordship's conscience is satisfied that system is in public interest, your lordships can, Lord, accept my right to informational privacy as against general right to know. And why, my lord, I say this? If there is a genuine public interest in the disclosure, you go to the court, you have 7 for remedy. But merely for your curiosity, you cannot invade somebody's privacy if that privacy ultimately serves larger public interests. Lord, that's the submission which I have made. My lord, I have quoted the relevant paragraph. I am not, my lord, reading it. Your lordships are aware. Lord, please come to para 95. In the matter of Puttaswamy, this honorable Justice, it should be Justice Puttaswamy, this honorable court discussed the validity of section 33 of the Aadhaar Act, which provided for disclosure of information including identity. I'm sorry. I was on 95 reading Puttaswamy, second para, 95 second para. It is submitted that while upholding section 33, this honorable court, however, added a layer of safeguard as per which such information may be shared only upon an order being passed by the judge of a high court. Now, your lordships respected the privacy, but in public interest, if lordship says that if it is required, then of course with the order of the high court. So it's not, my lord, as if it's an afterthought which I'm suggesting to your lordships. It's already there in my written submissions, which shows, my lord, that the intention is not that there is no level playing field. Government, whichever is the party in power, knows about it, and the rest of them do not know. Nobody should know. That incentivizes clean money coming into the system. Then your lordships, my lord, kindly skip the rest and, my lord, come to, my lord, I have quoted, my lord, FAQs which are relevant, my lord, but broadly I have indicated, my lord, what are those, my lord, FAQs. Please come to, my lord. But this I have already argued. I will not, my lord, bother your lordships. Please come to page 48. My lord, here, my lord, I would respectfully seek permission to read only few paragraphs of the judgments, my lord, because your lordships had a valid concern that in some cases it can be quid pro quo, in some cases it can be misused also. Yes. Nobody says that it cannot be. Any system can be misused. There can never be a system which is so foolproof which can never be misused.
You are reading the Shirur Math case?
Yes, my lord. Lakshmindra Tirth, my lord, the Shirur Math, my lord. Kindly see the last 3 lines which are bold and highlighted, my lord. For your lordship's convenience, my lord, I have done this. I don't wish to read the whole. The saving provision contained in section 91 of the Act makes the position quite clear. An apprehension that powers conferred by this section may be abused in individual cases does not make the provision itself bad or invalid in law. This is, your lordships are aware, my lord, 7 judges case. 7 judges judge. It can, my lord, in Indian ingenuity is, my lord, popular around the globe. And general human ingenuity, my lord, everywhere this is happening. Then, my lord, please see 117. Similarly, in collector of customs versus so-and-so, this court observed the possibility of abuse of a statute otherwise valid does not import to it an element of invalidity. Further, in state of Rajasthan, it was said that it must be remembered. You know, these are very well put, therefore I am tempted to read. It must be remembered that merely because power may sometimes be abused, it is no ground for denying the exercise of power. The wisdom of man has not yet been able to conceive of a government with power sufficient to answer all its legitimate needs and at the same time incapable of mischief. No, there can never be a system. We have started, we have begun, and as I pointed out, the beginning is giving us fruits. Digitized money, my lord, is bringing clean money into the system. I have given the figures, my lord, of payment made by digital mode. Then, my lord, Keshavanand Bharti, in exercising the power of judicial review, the courts cannot be oblivious of practical needs of the government. The door has to be left open for trial and error. Constitutional law, like other mortal contrivances, has to take some chances. Opportunity must be allowed for vindicating reasonable belief by experience. Look, the government, which consists of all politicians, the parliament consisting of all people in politics, my lord, they discussed this threadbare and found that there may be some lacunas in the system, but this is under the circumstances the best system. My lord, that trial and error, my lord, the government is entitled to. My lord, then, my lord, I am not reading Mafatlal, but please, my lord, come to, my lord, I am not reading A.K. Roy also, please treat it as read. Please come to, my lord, PUCL also, my lord, is on the same lines, my lord, therefore there is no point in duplicating, my lord. Then, my lord, I have pointed out, right, my lord, legitimate state interest. But your lordships would always balance. I have argued this, my lord, I will not take your lordship's time further. But the legitimate state interest is linked to public interest. So you have the right to information, no denial. But you have the information which company purchased how many bonds, and you have the information in public domain which party got how many electoral bonds. If anything beyond that is encouraging cash, my lord, economy to enhance, my lord, that your lordships can balance, and that would be in the legitimate state's interest. That public interest would be of paramount consideration when your lordships examine this, my lord. Lord, please see para 130. It is submitted that specific judgment in PUCL and SO, my lord, which were referred to by them, sought disclosure of information which was already in the knowledge and possession of the state authorities. When they say that you declare what is your property, you declare what are the criminal proceedings, these are all in public domain. At once platform you declare, but here you are trying to lift the veil of confidentiality, which is by design made a part of the very system and which is the pivotal part of that system. And even the government doesn't know it. So, right to information cannot be claimed from me. Of course, all views are concurring except on the ground of, except the question of money bill. Privacy, your lordship gets that? Privacy and proportionality are two interlocking themes that recur consistently in the above judgments. Privacy, also construed as informational self-determination, is a fundamental value. There is a consistent emphasis on the impact on personal dignity if private information is widely available and individuals are not able to decide upon its disclosure and use. This right of controlling the extent of the availability and use of one personal data is seen as a building block of data protection, especially in an environment where the state of technology facilitates ease of collection, analysis, and dissemination of information. Then your lordships may, my lord, kindly see how, my lord, the judgments cited are different. My lord, I have already said.
Yes.
My lord, level playing field, my lord, I have dealt with at page 64. But, my lord, I have already, my lord, orally made submissions before your lordships, my lord. But kindly see, my lord, 151, para 151 at page 65. I have already marked, my lord, which portion I'll skip and which portion I think I must assist your lordship with. 151. The petitioner claims that there is an incumbent bias as a large amount of money go to the ruling party. It is submitted that whether such an incumbent bias exists, and if it does, what its extent would be is a question wholly irrelevant to determining the constitutionality of the scheme. And my lord, I have already said that that has been the trend. The ruling party gets maximum because ruling party has the confidence of the maximum people. Yes. Now, my lord, page 65 bottom. My lord, I have said that secrecy per se is not alien concept in even electoral issues. Secrecy of ballot.
That's something separate. Yeah, in the uneven level playing field, you've referred to fairness of elections. That issue is not been addressed.
Correct.
Has that issue with regard to fairness in elections been, or because of the mismatch between the money power, has that been addressed here? Because that may be a larger picture, not specific, like alone to.
I'll just, my lord, again, my lord, try and attempt to point
No,
out.
you have argued that because of ruling party has always been getting substantially more donations.
My lord, average Indian voter, be it corporate or an illiterate voter, my lord, we have to accept this fact. And we should be proud of that fact. He is a very intelligent decision maker. A ruling party in 2013, though ruling party may not get maximum my lord, political contribution because the voter knows that in 2014 the wind is somewhere else. We have to trust his discretion. So ruling party is not getting maximum because of the scheme. That's my submission. The my lord,
According to even otherwise, the ruling party would get.
always, Lord, even before this scheme, I have shown from 2005 to 2014, whoever was ruling party, Lord, BJD is a ruling party in one state of Odisha. They have maximum, Lord, political contribution. That's the trend. That's how the people of India contribute. It's not as if because of the scheme the ruling party is getting any benefit and there is no level playing field.